Judgment.
This is WPC 110 of 2022. This court, having considered the submissions made by the learned counsels for both the parties, finds that the interests of justice and fair play would be met if the matter is remanded back to the Appellate Authority Board of Directors to consider the appeal filed by the petitioner, wherein the chairman of the Board of Directors, who is also the disciplinary authority, should recluse himself. Yes.
I go Black's.
May I seek your lordship indulgence in mentioning part 2, item number 7.
Yes.
My lord, the standing counsel for,
Wait, part 2 list is not here. You have to remind them every time. Yes.
my lord, the standing counsel is in bereavement.
Item number 7.
Item number 7. So if this matter may be listed next week, my lord. We have taken the consent of the opposite party. Yes.
Okay, you are for the respondent.
Yes, my lord.
Okay, we have taken the consent.
Yes, my lord.
Mention is made on behalf of Mr. R. Lalmund Siama, learned standing counsel for respondent number 1 to 5 for adjournment of the matter since the learned counsel is out of station, and that consent of the other side has also been taken. In view of the above, list the matter after 2 weeks.
Yes. Okay.
Motion, item 1.
Yes.
May I please, your lordship, that this requisition was filed under Article 226 of the Constitution for issuing writ, and that the petitioner is the owner of a landed property covered under periodic quota number 502008 /10/1291 of 2010, located at Molkhang, Kolosip district. And in the year around 2020, the respondent number 4, that which is the railway, have encroached the petitioner's land. And they occupied and damaged the landed property for construction of the railway line and railway station without paying any compensation as per the law. And for this, representation have been submitted to the Deputy Commissioner. On 9 April 2025, but till now, the representation was not responded.
So can we dispose of the matter
Yes, if
by
possible, my
asking
lord.
the respondents to respond to your representation? Where's your representation page?
If I may take you to page number 17, annex 5.
17. But this is not signed, number 1, okay? Not signed representation. The Deputy Commissioner will not consider a reputation which has not been signed. Is there a copy of the signed representation with you?
Yes, my lord.
Then you submit the required this thing,
Okay.
and then we'll have a look at it again, okay? Simply saying I submitted this representation which was not signed by you, then you have no grievance if you have not submitted a representation duly signed by you, isn't it?
Yes, my lord. It was duly signed by the petitioner and it was received by the DC Colosseum. The first
But
page.
where's the signature? Page 18.
Apologies, my lord, if I may kindly allow to change this one.
Okay. Third, Mr.
Zo din pe nam te.
The learned counsel for the petitioner who prayed that he may be allowed to submit the correct document, annexure 5 in the writ petition, since it appears that the wrong annexure has been filed in the writ petition. In view of the above submission, the learned counsel for the petitioner to do the needful, list the matter. But in the next week,
Yes, my lord.
contact your client first, isn't it?
Yes, ma'am.
See, because even if you say it's not been addressed to, I'm sure the deputy commissioner, if this is what you have submitted, will say this is not signed, we cannot consider,
My lord.
isn't it?
My lord. Much obliged.
Item 2.
Yes.
May I please, your lordship? My lord, this present writ petition is filed under Article 226 and 227 of the Constitution, challenging the legality and validity of the fresh complaint or the second appeal dated 2309-2024, which is filed by respondent number 7, and also the consequential impugned order dated 2304-2025 and 0307-2025 issued by respondent number 3, as these acts are in complete violation of law, jurisdictional norms, and fundamental rights of the petitioner, my lord. My lord, if I may present the facts of the case.
Yes.
My lord, the petitioner is a bona fide citizen who is allotted land at Chimluang Kam Serkhan by the Serkhan Village Council in the year 2000. And he has been continuously developing the land and also maintained the land for almost 2 decades by cultivating areca nut and the palm. And this shows that there's a lawful allotment and land has been developed. And also, in recognition of his lawful position and development, the revenue also issued three periodic pattas, that is periodic patta number 808, 809 and 810 in the year 2007, which covered the said land. And
Okay, however, wait, let's see, page 4, okay? However, the compensation amount of the petitioner's land covered by periodic patta number 809 of 2007, isn't it, has been pending due to disputes between the petitioner and respondent number 4. Who is respondent number 4?
my lord,
Private
respondent
person?
number 4 is,
Private respondent?
no, my lord, is the director, land revenue and settlement.
So how can there be a dispute between both of you? What sort of a dispute?
My lord, what happened is that the respondent number 7, if you look at,
Yes, please read. So, respondent number 7.
oh, my lord, this, I suppose is a clerical mistake, my lord. Supposed to be respondent number, I mean,
Which one? Something between respondent number 4. So there's a dispute between you and maybe must be a private respondent. Because how can you have a dispute with the director?
my lord, the only issue that was with the director is that the respondent number 7 stated that there was a mistake in his periodic patta, which mentions that the direction of the pata was falsely given in the periodic pata. So he made a complaint to the respondents stating that the periodic pata has to be corrected.
So
So
was it
after-
corrected?
It was corrected, my lord. And after correcting the periodic pata with the direction, it affected the land, it affected my land. That is 809 of 2007. Whereas in the other periodic patas, there was no issue, compensation was already.
Given to him?
Yeah, yes, my lord. And due to this issue, periodic pata 809 could not be settled. The compensation could not be issued to the petitioner. My lord, that happened after the acquisition for national highway took place for this particular periodic pata 809.
So your dispute is settled? You have been issued?
No, my
the
lord.
Correct? Then settle that first.
My lord, the issue here, my lord, is that instead of taking the appeal to the High Court, the respondent has continuously went back, taken a second appeal to the respondents, that is to the Revenue Department. Which is why I mentioned at the beginning, my lord, that since the respondent has taken the second appeal again to the secretary should not have entertained that particular complaint. After the secretary has made an order and the director has also stated, made an order, he again went back to the revenue secretary. Since the revenue tribunal is not functioning, he should have come to the High Court. Instead of that, he has taken a second appeal to the same revenue department, which has caused this particular issue.
So you will come in form of a civil revision petition under 227 or it's a writ petition under 226? You have mentioned both the section articles.
My lord, we have mentioned 226 and 227.
227 is a civil revision petition.
Yes, my lord.
Then,
My lord, the thing is that,
so you are appealing against, you are
lord,
unhappy with which order? You are unhappy with which order?
my lord, with the order 23/4/2025 that is in page number 41
Page
and
41.
also, yes, my lord, page number 41. My lord, what we are unhappy with is that respondent number 7 has, after the director has passed the order, unhappy with the order, has went back and has taken a second appeal to the secretary.
Who's
So,
the appellate authority?
my lord,
Who
if
is
it
the
is a
appellate
second
authority?
appeal, my lord, if it is a second appeal, my lord, it would be the violation of statutory appeal mechanism, my lord. It is
So
with the
let's see
revenue.
the revenue, this thing. Simply saying, show me, revenue. Mizoram revenue, this thing. See, you have it ready with you so that we can see. The Mizoram land revenue laws. Okay. So where's the appeal provision?
My lord, in section 90, my lord,
Section 19,
if the respondent was to take the second appeal, my lord,
So what happened here? First,
my lord, first the respondent made an appeal to the secretary, my lord.
the respondent make an appeal to the secretary. Penalty for section 19,
90, my lord.
90. So the first appeal was when?
My lord,
Was placed before?
was placed before the settlement officer, my lord.
Okay, settlement officer.
Yes, my lord. And with pursuing this complaint, my lord, a spot verification was conducted. And on, yes, that was on 20/09/2023, my lord. And passed an order revoking the corrected pata of respondent number 7, my lord. It was found that the new claim intruded into the Serkan VC jurisdiction, while the original pata was linked to Konpui VC itself. And then the respondent number 7, unhappy with that,
You can prefer an appeal to the collector or director, isn't
yes, my
it?
lord, went to the,
So that is the first appeal. Then
Yes, my
second appeal,
and my lord, so the respondent number 7 went to the director, my lord. And the director also gave an order stating that the settlement officer's order has to be upheld.
may pass and prefer an appeal to the revenue commissioner or secretary. So the order passed by the settlement officer may prefer an appeal to the collector. That's the first appeal.
Yes, my lord.
Okay. Then, if such an order is passed by the collector or the director they passed, the appellant may prefer appeal to the revenue commissioner or the secretary revenue department.
Yes, my lord.
So that is also done.
Yes,
Passed?
my lord. So, my
Okay,
lord,
so you're still unhappy with that.
no, my lord, what happened was, again, the respondent number 7 was unhappy with the director's order. And
With the
further,
director, so he went on appeal to the commissioner secretary.
appeal to the secretary, my lord. So what we are saying is that, as per section 90, a second appeal against an order passed by the first appeal has to be preferred before the tribunal, my lord. Instead of that, abusing the process, he undeterred and submitted a fresh complaint, my lord, or we could call it a second appeal to the secretary, that is respondent number 2, on 23/9/2024, which led to the impugned order, which I have mentioned earlier, that is 23/4/2025, and also 03/07/2025, my lord.
Because they have gone as per section 89. Okay. So section 89 provides that if unhappy with the settlement officer, they will go to the collector.
Yes,
and
my
from the collector to the secretary revenue department. So they have taken those steps.
My lord,
A second appeal shall against an order passed by the, if the order under clause C of subsection 1 so if the first appeal is passed under clause C,
yes, my
but
lord.
here you're saying the first appeal was preferred under clause B,
Yes, my lord.
then clause B, then it will be clause C. So what's wrong with that? Second appeal is clause C.
My lord, second appeal is already done, my lord.
C.
And again, unhappy with clause C, my lord, has further gone to the secretary, my lord.
But clause C is the secretary. So same person. I'm asking you to explain because I'm not very
Yes, my
clear.
lord.
Because here the language is very clear. A is the settlement officer.
Yes, my lord.
B is the deputy, is the collector, okay, to the collector or director. Then C is the, then appeal again lies to the secretary. So 3 steps are there.
Yes, my lord.
But if the third step, if there's an appeal under C, if the first appeal was preferred straight away to C,
Yes, my lord.
then the second appeal would be the tribunal. But in this case, from what you are telling me, from what I'm trying to understand from you, is that you had followed A, B, and C already, second appeal.
My lord, may I get back to little bit
No,
to the-
just clarify, because maybe the act itself is first appellate authority. So in the first appellate authority, from plain reading, it appears that if the first appeal,
Yes, ma'am.
instead of the director or from an order of the director, had gone to the secretary,
Yes, ma'am.
then the second appeal would be the tribunal.
My lord.
But in your case, the first appeal is to the collector, director, and then the second appeal to the secretary. Then,
lord,
then how can you?
If I may take you to
Oh,
page number 8, my lord,
Page number 8
point number 10
of what? Of your petition?
of the petition, my lord.
Okay.
That pursuant to the said letter complaint, second appeal, the respondent issued impugned letter 2304/25 directing the respondent number 5, that is Kala, and the deputy commissioner for stay of disbursement. So he has gone to the extent, my lord. So it would mean that he has exhausted his rights to give a complaint to the department.
No,
itself, my lord.
don't. Try and interpret section 89. 89 and your para 10. Come back
Yes, my lord.
next date, okay? Your para 10 and section 89
Yes, my
of
lord.
the Mizoram revenue, this thing. And also find out whether you're filing under 226 or 227. We'll see again this matter.
Yes, my lord.
Just try and clarify my confusion, which you have not succeeded so far. Yes, heard Mr.
David Lalampuya.
Yeah, David Lalompuya, learned counsel for the petition, was prayed for time to get direction regarding the writ petition. Okay, we'll leave it at that. List, when do you want it?
My lord, this week,
Anything,
if
on Friday? List on, yes, Friday's date, 25/7/2020.
yes, ma'am.
No, list on, no, it will be Thursday, 31.
Yes, my lord.
Yes,
31st July.
list on 31/7/2025. Yes,
Oblige.
that is on Thursday. Okay. Yes.
Oblige.
Admission, item 3.
Lordship, my senior Mr. Victor Eralte is the leading counsel in this case, and he is currently out of station. So may this matter be lifted after a week. Next week.
You're appearing on behalf of
Mr. Victor Eralte,
Victor. So what's happened to him?
he's out of station.
Okay. What about the respondents? Have you filed their counter affidavit?
Yes, my lord, I have filed the
Okay.
affidavit.
They're prayed for adjournment, not objected, isn't it?
Not objected.
Mention is made on behalf of Mr. Victor L. Ralte, learned counsel for the petitioner for adjournment of the matter, which is not objected by Mr. Lal Roku Mapautu, learned counsel for respondent number 1. In view of the above, as prayed for, list after 1 week.
Oblige.
Item number 4.
May it please your lordship, I'm appearing on behalf of the state respondents. We are yet to receive instructions. I've already sent a reminder just last week, your lordship. So if 2 weeks are may be granted.
Yes, okay. Miss, the good name, is your name here in the cost list?
Lal Nunlu, your lordship.
Okay, Miss Lal Nunpui, is it? Your good name?
K. Venetia, Your Lordship.
Oh, Miss
K. Venetia.
K. Vanessa is present on behalf of her senior,
Mr. Victor El Rate.
because your name is not here, isn't it? Appears on behalf of her senior, Mr. Victor L. Ralte, learned counsel for the petitioner, while Miss Lal Louis, learned government advocate, has prayed for further time to file the additional, is it additional?
No, your lordship, affidavit in opposition.
If I may, my lord.
No, In terms of this court's order dated 0804, additional affidavit, it appears.
If I may, my lord,
Uh,
that is for the respondent number 2. There was a direction to file additional. That is the NHI DCL, my lord.
Okay, but here maybe there's a mistake
There
for the
was a
state
mistake.
respondents.
Yes, ma'am.
Okay. Okay, Ms. Lalundui, learned government advocate, has prayed for time to file the counter affidavit. Have you filed the additional?
We'll be filing within 2 weeks, my lord.
While Mr. Samuel Vandev Shetachante, learned standing counsel for respondents number
2, my lord.
2, submits that they would be filing the additional affidavit within a period of 2 weeks.
Yes, ma'am.
Yes, then, Zairam Sangpui, anything to be done?
My lord, I am for respondent number 1. 2 weeks may be given for filing my affidavit.
Ms. Zairam Sangpui, learned CGC for respondent number 1, also submits that 2 weeks' time may be given to file their counter affidavit. Would stop her. Ms.
My lord, I'm also appearing for respondent number 6.
So,
My lord, we are awaiting the outcome of the additional affidavit to be filed by respondent number 2.
okay. Ms. Naisaki, learned counsel for respondent number 6, submits that she may be allowed to file the counter affidavit after the additional affidavit is filed by respondent number 2. In view of the above submissions, this is the matter after 3 weeks for the learned counsels for the respondents to file their counter affidavits. Yes.
Catch your lordship.
Item 5.
May it please your lordship, I'm appearing on behalf of the state respondent 2, 3, 4, and 5. The matter was last listed on the 10th of June, and I had sought for time to file additional affidavit. Your lordship, I have received the instructions, so if 1 week time may be given to file the additional affidavit, your lordship.
Additional counter affidavit.
Yes, your lordship, additional affidavit to the counter.
My lord, I am for respondent number 1. I take 2 weeks' time to file.
Why, have you contacted the respondents whom you are representing? CGC,
Yes, my lord.
they know what's going on.
Till date, I didn't receive any proper instruction in this.
So call them, find out, isn't it? Okay. Because how long are we going to keep waiting? Anyway, Mr. Lalbiak Nungan Namte, learned counsel for the petitioner, is present, along with Ms. Lalnun Louis, learned counsel for learned government advocate for the state respondents, number
2, 3, 4, and 5, your lordship.
2, 3, 4, and 5, and Ms. Zairam Sangpui, learned CGC for respondent number 1. Stop. The learned counsel for the respondents, counsels, okay, for the respondents have prayed for further time to file their counter affidavit. In view of the above, this is the matter after 3 weeks.
Catch your lordship.
Orders, item 6.
Your lordship, this is a bail application, and it has been fixed for today.
Who is the additional PP appearing? One is Siami or Mrs. Mary?
My friend have requested me to pass over this matter for the time being. She's on leave, Your Lordship.
Okay, time being matter.
May it please your lordship. My lord, by filing this instant make appeal, we have challenged the judgment and order dated 05/03/2025, wherein the learned MSCT had awarded a sum of rupees 1,37,28,200 rupees to the respondent number 1.
This is how many days
And there is a
condonation?
delay of 47 days delay, my lord.
So it's on the quantum?
Quantum as well as on the liability of the appellant, because we have claimed that there is a contributory negligence on the part of the deceased, my lord.
Okay, we'll issue notice.
My lord.
Heard Mr. T. Zakima, learned counsel for the applicant slash appellant who has filed the instant application under section 5 of the Limitation Act, 1963 for the condonation of delay of 47 days as on 21/07/2025 in filing the MAC appeal against the judgment and order dated 05/03/2025 passed by the learned tribunal in MAC case number 1 of 2021. Issue notice to the respondents through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Obliged. Item 8.
Yes, this
Yes,
is
Lordship,
condonation application.
condonation application in connection with the connected appeal.
Oh. How many days?
Lordship, 1,883.
Why so many days?
Because the applicant
Oh.
is pursuing the case to another civil court. So before filing of this appeal, there has been a review petition. That petition was dismissed, and thereafter, an application under Order 9 Rule 13. That one also dismissed.
Okay, anyway, we'll issue notice first. Heard Mr. K. Dindiana, learned counsel for the applicant slash appellant who has filed this application under section 5, read with section 14 of the Limitation Act, 1963 for the condonation of 1,883 days delay in filing the connected appeal against the order and degree dated 26/07/2020 passed by the learned senior civil judge dash Roman 3 in eviction suit number 4 of 2019, as well as against the impugned order dated 13/07/2023 passed by the learned senior civil judge dash Roman 4 in CMA number 416/2023, arising out of A-O eviction suit number 4/2019. Full stop. It is submitted that the application was filed on 23/07/2025. Full stop. Then issue notice to the respondents through registered post with AD within 3 working days, returnable by 3 weeks.
Status
Yes.
respondent 2 and 3, Malad.
Full stop. Mr. Samuel L. Sankem, learned, you're appearing as additional,
Yes, ma'am.
learned additional AG for the state respondents number 1 and 2.
2 and 3. ma'am.
2 and 3 accepts notice. Therefore, notice be issued, no need to issue formal notice to the state respondents. Requisite copies of the appeal memo to be duly furnished to the learned additional AG. List after 3 weeks.
Thank you, Lordship.
Item 9.
Lordship, we have filed an application for rectification of some clerical mistake in page number 37 of the writ petition. Yes.
What is
What we
that?
have written
What
in
is the
the-
correction?
Correction is, Lordship, page number 37 of the writ petition, we have written 2010-2022.
Okay, so, and instead it should be,
Instead, we should have written 2010-2022. 2011-2022 should be replaced by 2010-2022. The prayer portion,
I
page
think we can allow this consent in nature, isn't it, Ms. Government Advocate, accept notice today? Huh? No objection, isn't it? But where's the prayer portion? I'm not seeing. Okay,
prayer
here.
portion,
Yes, 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 fine.
9th line from the
Yes,
top.
yes, on page
and-
7.
Yes.
Heard Ms. Seemal Swami, Mrs. Seemal Swami, learned counsel for the applicant who has filed the instant application. Isn't there some provision of law? You've not mentioned anything.
No, Your Lordship. This, with regards to the date only, Your Lordship.
For making some corrections in the WPC number 47 of 2025, wherein some clerical mistakes was made in the prayer portion of the writ petition, which requires clarification, rectification, not clarification, full stop. The learned counsel submits that at page 37 of the writ petition, the date within open inverted commas, 2011-2022, close inverted commas, should be read as open within the inverted commas, okay, 2010-2022. And accordingly, such a correction may be allowed to be made. Issue notice, Ms.
Yeah.
Mary L. Kiante, learned government advocate, accepts notice and submits that they have no objection to the correction / rectification required to be made in the connected writ petition number 47 of 2025. Oh, you want your names also? Okay, Miss Mary, so-and-so learned government advocate. Okay, come back. Ms. Zairam Sangpui, learned CGC, and Mr. Samuel L. Changte, learned standing counsel. Is it for respondents number? Submits that they have no objection. Instead of just one name, we have added some more. Then new para, in view of the above submissions. In view of the above submission made by the learned counsel for the petitioner, which is not objected by the counsels for the respondents, the learned counsel for the applicant is allowed to make the necessary corrections in the connected writ petition number 47 of 2025, and thereafter furnish a copy of the corrected portion of the writ petition to the learned counsels for the respondents. Full stop. IA number 114 of 2025 thus stands allowed and disposed of.
Lordship, if I may,
Yes.
by replacing the page only, or we have to find a new,
Just replace the page. Okay, the corrected portion, so you file it in the writ petition.
give you a touch.
Yes, so when is this stands disposed of? You said no, and the matter the main writ petition, after necessary steps have been taken by the learned counsel for the applicant slash petitioner, is to be listed after 2 weeks.
After 2 weeks. Biblioblanche.
Item 10.
Note, this is an application under Section 5 of the Limitation Act for coordination of
How many
100
days?
102 days for filing the connected appeal. And the reason for delay is mentioned in para 3 of the application.
It's okay, we'll issue notice. See, but, okay, I'll just mention, in your course title, the first para, you should also mention against which court's order, okay? Judgment and order dated so-and-so, and the impugnator passed by whom?
Yes.
Okay. On the first, in the course title itself, it should be clear. Otherwise, we'll have to again turn the pages and find out which court's order is it, isn't it?
Yes.
So in your course title itself, have that one sentence, passed by who, that mention that, isn't it?
Yes, I will make the
Then it
correction.
becomes clear straight away. Now we have to turn the pages and find out who has passed this order against which you are going to file an appeal.
Yes.
Oh,
It's,
anyways, heard
Ram Murmu.
Mr. Ram Murmu, learned counsel for the applicant slash appellant, who has filed the instant application under Section 5 of the Limitation Act, 1963, for condonation of a delay of 102 days in filing the connected appeal against the impugned judgment and order dated 22/11/2024 and the impugned decree dated 13/01/2025, passed by the learned civil judge, senior division -1, Roman 1, in declaratory suit number 24 of 2010. Full stop. Yes, issue notice to the opposite party slash respondents through registered post with AD within 3 days, returnable by 3 weeks. Full stop. Then Ms. Lalnunlui, learned government advocate, accepts notice on behalf of the state respondents number
5, 6, and 7, Your Lordship.
5, 6, and 7. Full stop. No need to issue formal notice to the state respondents. Full stop. Requisite copies of the application to be duly furnished to the learned counsel, learned government advocate. Yes, list after 3 weeks.
Much obliged.
Item 6.
Oh, time being matter.
Yes, my lord. This bail application, it's arising out of criminal trial number 1381 of 2023, SR number 278 of 23. Your Lordship, if I may be kindly allowed to start with the small facts of how the petitioner was arrested, Your Lordship. On 11th June of 2023, Your Lordship, Sub-Inspector F. Lalun, of Excise and Narcotics Department, upon information he received, had detained one Ashok Leyland truck at Zemabok Aizol, Your Lordship.
So you have approached this court before, is it?
Yes, Your Lordship, and this honorable
So
court,
new grounds, not the
Yes.
same ground. What
the
is the
same
new
ground.
ground?
Your
What
Lordship,
was your previous
earlier-
ground?
the earlier bail application, Your Lordship will see that was dismissed on the ground that it was premature, and prosecution witness have to be examined first to see whether the petitioner is connected, is involved or not. And Your Lordship, only 4 witnesses out of 14 in the last 2 years has been examined. And my lord, the seizing arresting officer at the case IO has admitted that they have no evidence against the petitioner, and he was arrested only on the statement of the co-accused, who was the driver of the truck. My lord, in that note, if I may take a lot, we have annexed the deposition, if I may take a lordship, to para 80, page 88, your lordship.
Page?
88. From 88. This is the witness number 1. He is the arresting officer, your lordship. And if I may take a lordship to page 90, your lordship. First examination, your lordship. From point 1 to 6, your lordship. It is a fact that accused Kutbul Alam Laskar was not riding in the vehicle from where the essay was recovered. It is a fact that I did not seize any document or mobile phone in connection with the incident case. It is a fact that accused Kutbul Alam Laskar was arrested based upon the information received by us. However, no contraband substance was recovered from his physical condition or from the vehicle he was riding in. It is a fact that there were no documents seized with regard to the Ashok Leyland, and there are no documents regarding the ownership of the same. It is a fact that I did not make any disclosure statement in respect of accused Kutbul Alam Laskar. I did not take steps for recording confessional statements of Kutbul Alam Laskar. And your lordship, at page 92, the case IO has been examined, and the relevant portion which I want to show your lordship is page 95. At page 95, your lordship, at the bottom part, cross-examination by the counsel from. It is a fact that accused Kutbul Alam Laskar was not riding in the vehicle from where the essay was recovered at the time of seizure. It is a fact that the phone of the accused was not seized. Apart from his own statement, there are no incriminating evidence against the accused. It is a fact that the seized Ashok Leyland belonged to Abdullah Barboya and the seized Scorpio belongs to accused Lalman Omar. There are no records, messages, or the like to show that the accused was in contact with Abdullah Barboya in the charge sheet. And the next part, it's important, Lordship. Apart from the statement of the co-accused, there is nothing to show that the accused have received the contraband substances or that he was involved in the transportation of the same. Your Lordship, regarding statement of co-accused, the apex court has clearly stated, Your Lordship, that no conviction can be based only on the statement of the co-accused, Your Lordship. If I may kindly take a Lordship to the Surinder Kumar Khana versus Intelligence Officer, DRI, Your Lordship.
Citation?
2018, Volume 8, SCC 271.
Para?
At para number 13 and 14. If I may kindly read, Your Lordship.
Yes.
In the present case, it is accepted that apart from the aforesaid statements of co-accused, there is no material suggesting involvement of the appellant in the crime in question. We are thus left with only one piece of material, that is the confessional statement of the co-accused as stated above. On the touchstone of the law laid down by this court, such a confessional statement of a co-accused cannot by itself be taken as a substantive piece of evidence against another co-accused and can at best be used or utilized in order to lend assurance to the court. In the absence of any substantive evidence, it would be inappropriate to base the conviction of the appellant purely on the statement of co-accused. The appellant is therefore entitled to be acquitted of the charges leveled against him. We therefore accept this appeal, set aside the order of conviction, on conviction and sentence and acquit the appellant. This is in relation to NDMPS case in Lordship. So the case IO has admitted, the seizing officer has admitted that only because of the statement of the driver, he was arrested, and there is no other record in the charge sheet which shows the involvement of the petitioner in Lordship. My Lord, my next point is, my next ground I would like to base, Your Lordship, is that the arrest of the petitioner is in violation of Article 21 of the Constitution. Article 21, Your Lordship, says that no person shall be deprived of his liberty except according to the procedure established by law. That procedure established by law, Your Lordship, has been, in respect of arrest, has been incorporated in section 36 of the BNSS, Your Lordship. The corresponding section in the CRPC is 421B, Your Lordship. Section 36, Your Lordship.
So,
It
well,
says
let's
that,
see the arrest memo.
yes. The arrest memo, Your Lordship, is at page 32. The arrest memo in respect of the petitioner. Here, I would like to point out in the arrest memo, Your Lordship, that there are no civilian or independent witnesses to the arrest. The two witnesses are Constable 645 Laremsara of the Excise and Narcotics Department and Constable 680 Lalbiat Moya of the Excise and Narcotics Department. The party, the police who has arrested the accused, are putting themselves as the witness, which is a direct violation of section 36 of the BNSS.
Which part does it violate?
Section 36 BNSS, Your Lordship. If I may read.
Yes.
Every police officer while making an arrest shall, A, I'll take you directly to the B. B is the part. Prepare a memorandum of arrest which shall be here attested by at least one witness who is a member of the family of the person arrested or a respected member of the locality where the arrest is made. It has to, at least one has to be an independent civilian witness, Your Lordship. And Your Lordship, this violation will result in the violation of Article 21 as stated by in Romila Thapar versus
Citation.
Union of India, 2018-10 SCC 753. Para 77 and 78. Your Lordship.
What does it say?
So, if I may kindly read, Your Lordship. 77. One of the circumstances which must certainly bear upon the fairness and impartiality of the process which has been followed by the investigating agency is in regard to the importance of two punch witnesses from Pune when the arrest was carried out. Section 421B, this is, Your Lordship, section 36 of the Code of Civil Procedure emphasizes the importance of an independent witness while making an arrest. Section 421B of the Code provides as follows. Prepare memorandum of arrest, at least one witness who is a member of family or respectable member of the locality where the arrest is paid. The two punch witnesses in the present case are employees of the Pune Municipal Corporation. It is not disputed before this court that they traveled as part of the police team which made the arrest. 78. It was in DK Basu versus State of West Bengal that this court laid down requirements to be followed in all cases of arrest, which included the following. 35. 2. That the police officer carrying out the arrest of the arrestee shall prepare a memorandum of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall be countersigned by the arrestee and shall contain the time and date of the arrest. This court observed that the requirements it has enunciated emanated from Articles 21 and Article 22(1) of the Constitution and need to be strictly followed, failing which action for contempt of court will be initiated. So this is it's a mandatory procedure, Your Lordship, and it emanates from Article 21 to 22(1) of the Constitution of India. So the arrest is totally illegal, Your Lordship. And Your Lordship, just last week, the driver of the truck on whose position the narcotics were found has been released on bail.
Where? By which court?
By
By
the
the
coordinate
district
bench of this court.
By?
The coordinate bench of this court, Your Lordship.
But how come it was placed before a different bench when it arises out of the same FIR?
Yes, my lord.
That should have been pointed by the councils. When it arises
I'm
out
aware
of
only
the,
yesterday that there was an order.
when there is arising out of the same FIR, it should be placed before the same bench unless the bench is an outstation What,
My lord, the council,
judge?
even the council is from out of station in this, and
No, but the judge is outstation, and as per roster, they're not likely to come to the same bench. If it's not for that, then if it's arising out of the same bail, but then again, this is the same accused, isn't it?
no,
They should-
not same accused.
No, same accused means you had previously approached this court for the same accused,
For the same
which
accused,
was not granted.
granted.
So this is very wrong,
Anyway,
because
Lord,
it's the same FIR. Then it should be placed before the same this thing. This is what happens, no?
so, the registry should have,
They should have taken care. When was this?
This was
Dated
on-
very recent,
very recent, Your Lordship.
14.
So we have come across this only yesterday, Your Lordship. And my Lord, but I would like to say that this is the person on whose possession narcotics were found. I am not in possession of any narcotics. It is only on Nazimul Hussain Borboya's imputation that somehow I was involved with no other independent or concrete evidence that I have been arrested, Your Lordship. And if I may take Your Lordship to para 16 of this judgment, this order, Your Lordship. This bail was granted on two grounds, Your Lordship, before that. One is that the arrest memo is too vague. Two, it does not even contain the provisions of law under which the arrest was made, same as my case. And that cannot be found as a grounds of arrest.
Okay, now in the arrest memo,
Yes, ma'am.
uh,
No section.
you are serial number 2 or 1.
In the arrest memo, I am the
What's your name?
Kutbul, Your Lordship.
Serial
Kutbul.
number 1.
Yes, Your Lordship. And the second ground, Your Lordship, bail was granted to the co-accused is that only 4 witnesses out of 14 witnesses has been examined, and the petitioner has been in jail for more than 2 years, 1 month, 18 days, Your Lordship. And as per the judgment cited by the court, Your Lordship, that is Rabi Prakash versus State of Odisha, reported in 2023 SCC online,
Where? You're reading from where?
para 16, Your Lordship.
Of the judgment of the coordinate bench of the
Yes,
court?
yes,
Yes, okay.
This Rabi Prakash, Your Lordship, the citation is 2023 SCC online SC 1109. It says that prolonged incarceration
So
generally,
for prolonged incarceration, that's enough. You don't have to
it's
read
a
it.
violation of Article
Oh,
21.
no, prolonged.
So,
2 years, how long? How long has he been in custody now?
2 years, 1 month, 18 days, Your Lordship.
Oh.
And if Your Lordship required, Your Lordship had recently rendered 2 orders, their orders, where 1 year, 7 months have been granted by Your Lordship.
But different reasons will be there. It's not always the same. It will not be, if I'm not mistaken, it's never only for prolonged incarceration. Something is always there. So
And-
don't, so leave it at this, enough.
Yes, and my lord, just one more point is that the last bail order rendered by Your Lordship, which was rejected, Your Lordship has specifically stated the trial should be expedited. But
When was that dated?
That
Just a few
was
months
in-
back, 2 months back, expedited in 2 months' time, it cannot be completed.
it's 2 years, Your Lordship. There was a lot.
Okay, it's, okay, 2024.
Yes, Your
Is
Lordship.
it?
Yes, Your
1
Lordship.
year, it can't be 2 years.
No, the entire incarceration is 2 years.
After 1 year, you're saying.
Yes.
The charge sheet was submitted then? Previously?
It was submitted already, Your Lordship. Page 84 is the,
No, on 09/05/2024, when the previous bail application was rejected,
yes, Your Lordship.
was a charge sheet.
Yes, submitted,
Submitted.
already submitted. At para 7, Your Lordship will see of the order, considering the fact that charge sheet has already been filed. This court finds it appropriate the involvement of the petition
So
be looked
from,
into.
on 09/05/2024, no witnesses were examined. So as of date, after 1 year, you're saying how many witnesses? 4.
4 out of 14. And, my lord, why, as per this bail or earlier bail order was rejected, because to see whether a time were given to the prosecution to adduce evidence to see whether the petitioner was involved. And we have read out the cross-examination of the IO and the resting officer who admitted that the only evidence against the petitioner is the statement of the co-accused, which the Supreme Court has said that it cannot be taken as a substantive piece of evidence. That being the case, there is no likelihood of conviction at all, Your Lordship.
Anyway, so, yes.
Yes, Your Lordship. May it please Your Lordship. Your Lordship, what I would like to mention here is that regarding the examination of the PW number 1, which the bail order, the first bail order given time to the prosecution that to prove that whether the involvement of the present petitioner was there or not. And here, my lord, in the examination of PW number 1, that is the seizing officer, that is in page number 88.
Yes.
Para number 6, Your Lordship. If I may read out. We interrogated the said driver and handleman. I found out that there are some other persons who were deeply involved in this heroin trafficking, and they were not far from the place of occurrence. The duty team were split into 2 teams, find the other person at Zemabok locality. Luckily, on 11 June 2023 at 2:15 a.m., we saw another suspected heroin possessor, Kutbul Alam Laskar, that is the petitioner, of Daksin Mahanpur Sonai Kachar district, Assam, and Sukur Ali Mazumdar, so and so. And in para 7, after the driver and handleman confirmed they are involved in this case and the accused Kutbul Alam Laskar was the mastermind of the case, I therefore arrested Kutbul Alam Laskar, so and so, and Sukur Ali Mazumdar, so and so, on 11 June 2023 at 2:15 a.m. in presence of the same reliable civilian witness in connection with the previous seizure.
So you arrested on 11 June. Where's the arrest memo? Let's come back to that. Page.
Arrest memo in respect of, is in page 32, Your Lordship, page 32. It has here clearly written at para number 2, page 32, Your Lordship. The true type copy is at page 33. It might be
Arrested on 11th June, isn't it? 11th June.
2:15 a.m. Here, not at para number 2, we will see that arrest was made in light of interrogation of accused person MD Nazimul Hussein Burbuya, driver of the seized truck, who accuses the rifle. So it's only on the imputation, Your Lordship.
Anyway, so in the presence of reliable civilian witnesses,
No civilian witness, constables, Your Lordship.
where's the Caesar memo?
Caesar is in respect
Caesar and arrest memo.
of, yes, page 30, Your Lordship. Page 29, page 29. 29 is the type copy of 28. This is the Caesar memo, Your Lordship. So we will see
So
that
Caesar and arrest memo,
it is the two. I was not arrested here, Your Lordship. I was not
okay. Your name is not here.
not here. I was arrested later, Your Lordship. Upon custodial interrogation of those 2 persons here,
Okay, so in the first Caesar and arrest memo, it is in the presence of 2 civilian witnesses. This was on 11th June.
11
And then
June.
later you were arrested, but
And
when you
later in
were
a
later
different place.
arrested, it was not in the presence of 2 civilian witnesses. That is yours, huh? Yes.
And Your Lordship, from the statement of the case IO, it is clear that the accused himself admitted his guilt,
Where?
and that is in page number 92, para number 4. I also interrogated accused Kutbul Alam Laskar, who stated that on 6/6/2023, he himself, along with Nizamul Hussain and Sukur Ali Mazumdar were sent to Champai to deposit balu sand by Abdullah Barbuya from Kachar district, Assam, with the seized vehicle, that is Ashok Leyland, on 9/6/2023. They unloaded balu, which is received by accused Lalngai Oma, who is already conducted by accused Abdullah Barbuya. On 10/6/2023, they departed Champai and removed registration number plate of the seized vehicle as they are going to transport some amount of heroin. At noon, while reaching Khozol, Abdullah Barbuya contacted him and told him to receive heroin from accused Lalngai Oma. He then drove the vehicle with Sukur Ali Mazumdar and took another road and went to safe place, which is followed by Scorpio owned by accused Lalngai Oma, and received heroin from accused Lalngai Oma and concealed the same heroin at secret compartment of the seized vehicle. After concealing the heroin, he handed over the seized vehicle to
Oh,
the
so this is
driver.
the statement recorded.
Yes, Your Lordship.
So what happens to the statement recorded? What is the
Evidential
value?
value.
Evidential
Yes, Your Lordship.
yes, on that.
Citation, Your Lordship. 2022 SCC online SCC 2109. Even here, Your Lordship, the appellant, the petitioner was arrested from the statement of the co-accused. And in para number 9, Your Lordship. However, going by the circumstances on record at this stage, on the strength of the statement of Muhammad Nizam Uddin, though allegedly retracted later, the matter stand on a different footing in our considered view. In the face of the mandate of Section 37 of the Act, the High Court could not and ought not to have released the accused on bail. We therefore allow this appeal, set aside the view taken by the High Court, and direct that both the appellants be taken in custody forthwith.
Going by at this stage, on the strength of the statement made by Mr. Who is this? Azimuddin?
That is the co-accused, the driver, even in this.
So you are saying that the statement of the
Yes.
co-accused,
What the counsel is stated that he was arrested based on the statement of the driver only.
okay, so you were saying that a statement of the co-accused can be a ground for
Yes.
not granting them bail.
Yes, Your Lordship.
My lord, to rebut that, I have the citation, full bench of the Supreme Court, Your Lordship. It is State NCB Bengaluru versus Pulabit Ahmad Amrita 2022, 1 SCR 422. This is in relation to 21C of the NDMPS case, Your Lordship, at Parad 12, 2022, 1 SCR 422, Parad number 12, Your Lordship.
Yes. I'm waiting.
2022 1 SCR 422. In this case, Your Lordship, this is a full bench. It has the
See,
my lord, if I may take you to page 8 of my petition, it's there in page 8, Your Lordship.
you have the copy ready, otherwise you have the book unless it is in the SCC online.
Yes, Your Lordship,
What?
it's my mistake, Your Lordship. SSD online, I thought I have given this, but I might have.
It's not here.
If I may
Page?
take page 8, Your Lordship, page 8. Of my bail application, Your Lordship. Have Your Lordship got it? This is regarding the statements. In It has been,
See by citation if there's an SCR. Bits and pieces like this. You can type anything you want. Anyways, you give me the text later.
yes, my lord, it states that I have written down here, Lord. It has
You
held,
have written down, but we'll have to cross-check later.
Ye-
What
yes,
you've
yes.
written is the same or not.
what has been stated in this judgment, your lordship, is that it has been held in clear terms in Tofan Singh versus State of Tamil Nadu that a confessional statement recorded under Section 67 of the NDMPS will remain inadmissible in trial of an offence under the NDMPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner, which is the NCB, on the basis of the confessional/voluntary statement of the co-accused recorded under Section 67 of the NDPS cannot form the basis for overturning the impeachment order released him on bail. This, your lordship.
We'll have a look.
And that in the Tofan Singh case also, your lordship, it has been said that confessional statement cannot be the basis of a conviction, your lordship. That's clear.
Yes.
Your
Anything
Lordship,
else?
if I may, in the judgment which I have just given it, even here it is mentioning about the case which he had mentioned, that is Tofan Singh versus State of Tamil Nadu in para number 8. The answer to said question could be the statement recorded of Mohammed Nizam Uddin, the statement of Mohammed Zakir Hussain recorded under Section 67 of the Act has also named his owner accused Abdul Hai. We are conscious of the fact that the validity and scope of such statement under Section 67 has been pronounced upon by this court in Tofan Singh versus State of Tamil Nadu, instead by NCB Bengaluru versus Palulabit Ahmed Arimuta. The rigor of law laid down by this court is Tofan Singh was held to be applicable even at the stage of grant of bail. So even in the judgment, it is criticized.
Okay, yes.
Yes, my lord, yes,
But let her complete, don't answer bits and pieces. Then in rebuttal, you can give here in one piece, okay? Because after you give, then again we listen, yes.
And
Anything else?
Your Lordship, regarding to the arrest, here in the arrest memo, the intimation was given, and even to his,
In fact, you can sit
family.
while she's making her submission, yes.
and what I would like to mention here is that minor non-compliance of certain procedure should not be the grounds to release accused on bail if no serious prejudice have been caused to the accused. That citation has given time and time by the
So
Supreme
give
Court.
it now.
I already gave my copy
Oh, yes.
in the last.
What is the citation?
Kashish.
Have you given?
No, my copy in the last court I have given it, so I didn't have time to print it out.
Which one, which one?
Kashif.
What is the citation? So you're saying not having a civilian witness is a minor non-compliance, is it?
Yes, Your Lordship.
Okay, which is the judgment?
2024 SCC online SC 3848. Narcotic Control Bureau versus Kashif. 2024 SCC online SC 3848.
Give it to them in writing, no, beforehand. Yeah, it's 3848. Click, get citation. Para?
Last para. Para 39, subclause 5. Any procedural irregularity or illegality found to have been committed in conducting the search and seizure during the course of
Search and
investigation.
seizure,
Yes, Your Lordship.
not arrest.
Not arrest.
Then, yes. That's it?
And yes, Your Lordship,
Yes.
from the statement, which I have already read out, from the statement of the witnesses, it can be clear that the involvement of the present petitioner is very deep, and he is the mastermind. And the contraband which they have seized is a commercial quantity. And regarding to the quantity and the involvement, my submission is to not to release the accused on bail at this stage. And that the trial is going on.
Yes.
Lord, I would like to take your lordship to one judgment where, my lord, this point is that if we go back to the arrest memo, we will see that the petitioner and the other person who has been arrested, they have made to sign their name by fingerprint, which shows that they are not literate in the English vernacular, your lordship. It is as if at the Supreme Court judgment, your lordship, I want to show is Bihan Kumar versus State of Haryana and other, 2025 SCC online SC 269. Why this is important, your lordship, is for the enforcement agencies to also in future make an arrest memo in the language known to the arrestee, your lordship. It will be as if it's been written in Chinese, your lordship, if they are illustrated in the English language. I would like to take your lordship to para 14
Para 14
of Bihan Kumar versus State of
What is the
Haryana,
citation?
2025 SCC online SC 269. First,
Para?
13
13.
and para 21.
Yes, 13 will be to Article 22, then 21, para 21 should be in the language known to them in writing.
Yes.
That one. Okay,
Yes,
give
it
it,
has to be that, your lordship. And that is 22 says that it's a fundamental right under Article 22(1). It has to be in the language, your lordship. So to sum up, your lordship, number one is that only evidence against the accused.
rebuttal of what she said.
Yes, your-
Done, you've done.
yes.
Then
And
you don't have to repeat yourself.
yes, ma'am. So since your lordship, that's my submission.
Okay. I'll pass the order later. Heard, okay. Mr. Jonathan L. Silo, learned counsel for the applicant slash petitioner. Also heard Miss Linda L. Fumble, learned public, also heard Miss Vani Siami, learned additional public prosecutor for the state respondents. Yes. Then rest I'll pass later to be out by today. Yes.
Obliged, Your Lord.
Disposed. Yes. Do we have a hearing matter today?
Oh, there's a supplementary.
Pardon?
There's a supplementary list.
Oh, supplementary. Yes. You should have called the supplementary.
Item 11.
My lord, in this case, I believe the government are not willing to refer the matter to mediation. My lord.
What is the matter about?
It's with regard to the engagement of the assistant professor part-time.
Okay.
Our engagement is till 28 to 2026. Now, the government has given us a so-called notice. So we have challenged that so-called notice, and We have also sought the direction from this court that we may be retained till the currency of our engagement period.
Okay. I heard Mr. Silal Fagzola, learned counsel for the petition, along with Ms. Vanessiami, learned government advocate for the state respondents. No, so you're saying the government is not willing?
The government are not willing.
It is here, the government council is here, let them say.
Yes.
I thought
I've-
you are the
no.
counsel for the government.
No, I'm
Yes.
sorry.
Yes, Your Lordship, this matter was taken by Miss Mary. And she informed me that she asked the
Okay.
department and they informed her that they are not
Okay,
willing.
yes. Along with Ms. Osa, the learned government advocate submits that though the matter has been identified for settlement through mediation, the state respondents are not willing to have, to make any attempt to settle the matter through mediation. In view of the above, list the matter after 3 weeks. What's the stage for the state respondents to file their counter affidavit, is it?
Yes, my lord.
For the state respondents to file their counter affidavit, yes.
In the meantime, my lord, if I may pray that status quo may be given to
Meanwhile,
disposal of the case.
Yes, as granted earlier, status quo may be maintained till the next date of
Till
listing.
disposal of the case, my lord.
Till the next date of listing.
Item 12.
Yes,
Yes, Your Lordship, in this matter, I have contacted the Aizawl branch head office of the Nation Insurance, and they replied that they have no authority to, it has to, if a proposal is sent, suppose it's, basically it's a quantum, the amount which has to be decided. So what
okay, we'll send it to this thing, mediation, by the time you get the whatever permission. Then if you're not willing at that time, you can mention there. Okay, because it has to be settled, how many matters to be listed has to be settled, decided within this month.
the matter has to be approved by the regional head from Guwahati, Your Lordship. That's the problem.
So if the regional office is willing, then when they are called for mediation, they should send someone.
Well, not what they've stated to me, if the claimant makes a proposal of the amount which they will agree to, then they can send that proposal to the regional head, and from there they'll get the approval or not. So that is the shortcut way of doing it. If the
So they'll
claimant,
send it to mediation and you can propose all those, isn't it? Whatever, this thing, make an attempt in the mediation first. Heard Mr. Jonathan L. Silo, learned counsel for, mediation has not started yet. It's sit in the mediation. Heard Mr. Jonathan L. Silo, learned counsel for the appellant, along with Mr. Benjamin Lal Samwana, learned counsel for respondents number 1 to 6. It is submitted that though the permission of the regional office of the insurance company is still required, however, since the matter is found to be appropriate for referring it to mediation, the councils submit that they have no objection at this stage. In view of the above, matter be referred to mediation, full stop, registry to do the needful.
obliged.
Right.
Part 2, item 2.
Yes.
May it please your lordship.
What?
Your Lordship, there is one supplementary item. The PPC 110 of 2022, item number 1 supplementary. There's another supplementary which is fixed for judgment.
Already pronounced?
Yeah, already done. I'm sorry, my lord. I was in the other court.
May it please, Your Lordship. My Lord, this appeal has been filed challenging the order dated 02/12/2024 that has been passed by the Civil Judge Senior Division 5.
What is the matter about?
My Lord, this basically is that I have a landed property and the instant respondent is my grandson, respondent number 1. Is my
Can the matter be referred to mediation?
No, my
My Lord, my Lord, let me simplify. Let me tell you, my Lord, the issue in this case, my Lord, before your Lordship sends it to the mediation. Before your Lordship passes the order, my Lord, let me just quickly, my Lord, give you the highlight of the case. Now, what happened, my Lord? The appellants, they filed a suit challenging a land which was mutated in my client's name. Now, the suit was dismissed on limitation during the first hearing itself.
Okay.
During the first hearing, there was no trial, my lord. So now this court has to decide, my lord. Now they have come on appeal saying that that could have not been done. So the only question in this case, my lord, is that whether the question of limitation could have barred them. So that's the reason why, my lord, if this matter can be decided at this stage itself, my lord, and the clients are definitely not willing to go on mediation, my lord. We have already consulted them.
Oh, they are related, isn't it?
They are relatives, but there is no, let me give your lordship the position, my lord. Now the appellant is the grandmother. The grandmother and the client, respondent themselves, my lord. Between them, there is no dispute. In fact, she has been living in my land for the past almost like 15 years. And I have constructed the land, the house, everything. Now, interestingly, my lord, on behest, I mean, this is almost like a sham case, my lord, where they have filed in the name of the grandmother. It actually filed by the uncle who has been taking all the steps. He wants the land to be in his name after the death of the grandfather. My client has no problem with the grandmother living in that house, my lord.
That's odd, no?
My lord, actually, even the facts are disputed, my lord. And
So,
the
no, I'm saying
Yes.
now there's the big drive for settlement through mediation.
yes, my lord.
And now we have these proper trained mediators
Yes.
who has undergone 40 hours of training. So now the judges all over India, the drive is in the national level to dispose of cases which have not been placed before the trained mediators. So since they are related, common grandmother,
Correct.
and there is no dispute that cannot be settled. Now, a perusal of the orders show that no attempt has been made, is it, to settle the matter through amicable settlement?
No, my lord.
So simply saying that they will not be able to settle,
Yes, my lord, I think, my lord, it's if your
make
lordship
one
has-
attempt,
yes, we can make one.
and
That
even in
can-
spite of that, they are not willing, then it's a different matter. But at any stage, it can be tried for mediation, because
That-
this is on technical matter. They can overcome those technical issues and come to a settlement if they have an open mind.
Yes. If
No,
I
your
may
lordship is
make
right.
one small submission, my lord, before sending this matter for mediation, my lord, the grounds for preferring this appeal is that whether the learned trial court could have
Whatever grounds,
could have
whatever
rejected,
grounds,
yes, could have rejected.
whatever grounds whatever grounds, ultimately, if the parties come to a settlement, those grounds really don't matter because they have no dispute. So what we're trying to do is cancelling the dispute. And if they can live happily ever after, then those little grounds of limitation doesn't make any difference.
And my lord,
If they have no dispute between themselves,
my lord is absolutely right. My lord, let me point out if the grandmother and the son, the grandson, my lord, if they sit together in one room, I am 100% sure, my lord, they will come into to a settlement. But if it is not the grandmother, if the uncle goes instead of the grandmother, my lord, then there will be no resolution. Because
So,
previously
so
also,
make sure when you go tell your clients when you go for mediation, you can mention, let the grandmother also come, so that we can all talk.
yes, the
See,
grandmother.
then
is-
whether barred by limitation or not barred by limitation, they have no dispute.
My lord.
Then the RFA and the dispute in the civil court also gets disposed of, because the parties don't have any dispute.
And my lord, regarding the facts, even the facts, the parties herein are a little bit different, because our case is that I have the respondent number one had approached me, and for using my land as a collateral security for securing a loan. I have not given him any
all
authority
those
for
can be
mutation.
settled. You see, ultimately, there
Yes.
have been examples when people are fighting over a piece of land.
Madam.
When they finally settled, the person who is saying it's my land, he's encroached, is willing to give more than what has been encroached. Because it's very little, you're making better use of my land, you take more land. Though it's my land, I will give you some more. That is the spirit of settlement.
Madam.
So this is a grandmother, his children, and maybe her children and her grandchildren. Is it?
grandson.
Grandson.
Her grandchildren, grandson.
What
who are
happened,
in
my lord?
dispute.
Yes, and I think that these facts can be settled because the reason is, my lord, during the lifetime of the grandfather, the grandmother and the grandfather, my lord, and the grandson, they transferred the land in the name of the grandson. Now, immediately after the grandfather died, my lord, I mean, the grandmother could not have woken up immediately after her husband died, my lord. Immediately after her husband died, the other side started taking steps.
But the
So
other
all
side
this-
is also the
that is-
grandmother's
yes,
son.
that
The
is not
other
my
side
facts,
is
ma'am.
also the grandmother's son.
That's true, that's true.
That
So
is
it's
not
a son, not
But
not a
But the
stranger.
difference is, my lord, with the son and this and my clients have taken the loan in their name. They built the house for the grandmother and the grandfather, they have
So
been living
maybe
in
a
that
little
land.
bit monetary, this thing here, I've spent so much, you can settle also. Because if I'm not mistaken, it's within the same building. Is it?
No,
They're
no.
going to see each other every day? No?
The building is, my lord,
It's a
independent
building on the floor.
No, no,
But compound?
no, my lord. Their
Completely
client,
different.
the son, my lord, lives in a completely different establishment, a big concrete house in different wing.
Okay,
My
different.
client also lives in a different place. The grandmother lives in a different place, and that house has been constructed by my clients. And so the grandmother
So
lives
they are
there.
fighting over that land where the
They are now,
grandmother is living.
yes, which was mutated, my lord, ages back in my name.
And also, my lord, I have been
So
verbally.
you try to settle the matter,
I've
make
been
one
verbally
attempt.
instructed
I think
by
it will be
the
best for them
respondent number
only, my
one
lord,
to
not-
vacate the premises.
Don't ask each other to vacate when you're all family members. Anyway, so let's see.
My lord.
Maybe you can come to some settlement before a trained mediator. Heard Mr. T. Lalzikima, learned counsel for the appellate. Also heard Mr. Joseph L. Rentley, learned counsel for the private respondents, and Ms. Caroline K. Lalungoy, Mrs. Caroline K. Lalungoy, learned government advocate for the state respondent number 2 to 4. This court, considering the nature of the dispute, which is between the family members, find it appropriate that this matter could be sent for mediation and the parties make an attempt to come to an amicable settlement, which it appears has not been attempted before. So, in view of the above, the learned counsels are to inform the parties that the matter has been referred to mediation for the parties to make an attempt to come to an amicable settlement. It's registry to deal the needful. Yes. make one attempt at least, then that's satisfaction.
My lord. Obliged.